A little tip about the use of restrictive covenants in employment law. I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. I want to offer you a little tip about the use of restrictive covenants in employment law. Now, usually people tend to think that restrictive covenants in employment law are at their most important if they're breached by the employee. This isn't true. They matter the most when they're being offered to the employee, whether that's in a contract of employment or an update to their contract of employment or even a settlement agreement. The reason for this is that the courts generally don't think very highly of restrictive covenants, so the employer really has to work hard to prove that they're necessary and that they're fair. So that all goes right back to the point where the employee is being offered the restrictive covenants because they need to be fair in their scope and how long they last for a court to come along and say, okay, Mr. Employer, I will grant you this. These are reasonable and we will enforce them for you. Therefore, the employer has to come to court with clean hands and essentially has to prove that those restrictive covenants are necessary and that they don't go any further than is necessary in protecting the employer's interests in their business, their clientele, who they want to work with, and how they want to work. I hope that's useful. In the meantime, if you're finding a settlement agreement hard, bring it to Richard.